Over 3 million files connected to the Epstein case have now been unsealed, released, or made public through courts, investigations, and civil lawsuits. These are not leaks. These are not rumors. They are official documents. Some of the most powerful people on earth are mentioned in these files, not accused, not charged, but present in records that were never meant to be read by the public. Tonight, we are not asking who is guilty. We are asking why, after millions of files, so few answers exist. This is not a story about justice served. This is a story about justice deferred, fragmented, and buried under layers of bureaucracy, political calculation, and institutional failure. For years, the public has demanded one thing: the Epstein client list, a single document, a roster of names, a smoking gun that would expose every person connected to Jeffrey Epstein's crimes. That list does not exist. In February 2026, Attorney General Pamela Bondi stated publicly that she had reviewed the files and found no incriminating client list. Authorities concluded that Epstein did not maintain a client list or use the gathered material to blackmail prominent individuals. This was not a cover-up. This was a reality that contradicted what millions believed to be true. The myth of the list has obscured the reality of what actually exists. What exists instead? What does exist is far more complex and far more disturbing than a single list. The Epstein Files consist of millions of pages of documents accumulated over nearly 2 decades. They include court depositions, FBI interview memos, flight logs, contact books, emails, photographs, videos, witness statements, grand jury materials, and investigative reports. On January 30th, 2026, the Department of Justice released over 3 million pages of documents. This followed an initial release in December 2025 that drew bipartisan criticism for extensive redactions and incomplete disclosure. These releases came after the passage of the Epstein Files Transparency Act in November 2025, a bill that passed the House of Representatives with a vote of 427-1. The Senate approved it unanimously. President Trump signed it the same day, but the volume itself creates opacity. 3 million pages. Who can read them all? Who can analyze them? Who can connect the patterns buried in depositions taken years apart, in different jurisdictions, under different legal frameworks? The files exist, but their existence does not guarantee understanding. The sources of the files. The documents come from multiple sources. Each source tells a different part of the story. The January 2024 unsealing came from a defamation lawsuit filed by Virginia Giuffre against Ghislaine Maxwell. These documents included depositions of witnesses, victims, and associates. 4,553 pages were made public. They contained the names of more than 150 people. Most of those names were already known. Judge Loretta Preska approved their disclosure precisely because the identities were not new. Many had only passing connections to the scandal and were not part of any criminal investigation. In September 2025, Bloomberg News obtained 18,700 emails from one of Epstein's personal Yahoo accounts. The emails spanned from 2002 through 2022. 4 independent experts reviewed the methodology and found no evidence of fabrication. The House Oversight Committee released tens of thousands of additional pages obtained from the Justice Department and the Epstein estate beginning in September 2025. November 12th, committee Democrats released 3 Epstein emails pertaining to Trump, including a 2011 exchange with Maxwell in which Epstein referred to Trump as the dog that hasn't barked because Trump had spent hours at my house with the victim. Hours later, committee Republicans released 20,000 additional pages from Epstein's estate. Trump was mentioned over 1,000 times, though none of Epstein's emails were sent directly to Trump or his staff. And then there are the documents that remain sealed. Grand jury materials. Exhibits that judges have refused to release. Communications protected by attorney-client privilege claims that legal experts have questioned, The files are not a monolith. They are fragments scattered across courtrooms, congressional committees, news organizations, and government agencies. The evidence catalog. Among the newly released documents in Phase 1 was a 3-page catalog of evidence seized during searches of Epstein's properties in New York and the U.S. Virgin Islands after his arrest in 2019, and a search of his Palm Beach mansion a dozen years earlier. The evidence includes approximately 60 pieces of physical evidence, photographs, travel logs, employee lists, more than $17,000 in cash, 5 massage tables, blueprints of Epstein's Island and Manhattan home, 4 busts of female body parts, a pair of women's cowboy boots, 1 stuffed dog. The files include a folder containing island blueprints, photographs, and other documents, a little St. James logbook, multiple logs of boat trips to and from the island, a document with names, an employee contact list. The files also include over 10,000 downloaded videos and images of illegal child sex abuse material and other pornography, a large volume of images of Epstein, images and videos of victims who appear to be minors. Most of this material would have been aired publicly had Epstein gone to trial, but Epstein never went to trial. A court order prohibits further disclosure of much of this evidence. Why volume creates opacity. 3 million pages of documents. If you read 1 page per minute, 8 hours per day, 5 days per week, it would take you over 3 years to finish. But reading is not understanding. Understanding requires analysis, cross-referencing, pattern recognition, legal expertise, contextual knowledge of how sex trafficking operations function, how elite social networks operate, how investigative failures compound over time. The sheer volume of the files creates a barrier to comprehension. It fragments attention. It overwhelms investigators. It allows critical details to be buried in mountains of administrative records. Opacity protects power, not through active suppression, not through conspiracy, but through complexity, bureaucracy, and the simple mathematics of information overload. When accountability requires reading 3 million pages, accountability becomes nearly impossible. The problem of redactions. Even the released files are incomplete. The December 2025 initial release was heavily criticized for extensive redactions. Hundreds of pages were entirely blacked out. Names were removed. Locations were obscured. Dates were hidden. The stated reason was victim protection. The Department of Justice claimed it redacted thousands of victim names to protect their privacy. But attorneys for some victims reported that the January 2026 release of 3 million pages contained unredacted images and identities of multiple survivors. On February 1st, 2026, attorneys representing more than 200 alleged victims asked federal judges, Richard Berman and Paul Engelmayer, to order the immediate takedown of the Justice Department's Epstein Files website, calling the release the single most egregious violation of victim privacy in one day in United States history. Deputy Attorney General Todd Blanche defended the department's procedures, saying redaction errors affected about 0.001% of all materials, and that the department moved quickly to fix mistakes when notified. The very protection the government claimed to provide had failed. Other redactions are harder to justify. References to powerful individuals. Details of investigative failures. Information about co-conspirators who were never charged. A draft indictment from the Southern District of Florida in the 2000s would have charged Epstein alongside 3 others described as having been employed by him. They facilitated appointments between Epstein and girls. Their names are redacted. The document describes them as having conspired to persuade, induce, and entice individuals who had not attained the age of 18 years to engage in prostitution. It is not the client list, but it is evidence of a conspiracy that was documented and then abandoned. The question is not what exists in the files. The question is what remains hidden within what exists. Public perception and distrust. A December 2025 Reuters poll found that 23% of Americans approved of Trump's handling of the Epstein case. A January 2026 CNN poll found that 49% of Americans were dissatisfied with how much of the Epstein Files the federal government has released so far, while 6% were satisfied. Two-thirds of respondents said the government was deliberately withholding information. This distrust is not irrational. It is a reasonable response to decades of institutional failure, broken promises, and incomplete disclosures. The files exist, but trust in the institutions managing them does not. Being mentioned in the Epstein Files is not proof of guilt. It is not evidence of wrongdoing. It is not an accusation. But it is not nothing. Presence in these documents matters because it reveals associations, patterns, and networks that were deliberately kept private during Epstein's life. The documents unsealed in January 2024 mentioned individuals including Andrew Mountbatten Windsor, former Prince of the United Kingdom, former Presidents Bill Clinton and Donald Trump, former New Mexico Governor Bill Richardson, lawyer Alan Dershowitz, singer Michael Jackson, and physicist Stephen Hawking. Most were mentioned in passing. Most were not accused of wrongdoing. But their presence raises questions that deserve answers. Andrew Mountbatten Windsor. The documents contain direct allegations against the former prince. Johanna Schoberg, one of many women who accused Epstein of sexual abuse, stated in her deposition that Andrew put his hand on her breast in Epstein's Manhattan townhouse in 2001. Virginia Giuffre alleged in her deposition that Ghislaine Maxwell directed her to have sexual contact with Andrew. Giuffre claimed Epstein paid her $15,000 to have sex with Andrew in 2011. Andrew has repeatedly denied these allegations. He stated he has no recollection of ever meeting Giuffre. In 2022, Giuffre settled a high-profile lawsuit against Andrew out of court. The terms were not disclosed. Andrew was removed from royal duties. His military titles were returned to the Queen. His use of the title His Royal Highness in any official capacity was discontinued. Witness testimony at Maxwell's trial in 2021 placed Andrew at Epstein's private island and other properties where victims say they were forced into sex. Former staff said he visited Little St. James several times. In 2006, Stephen Hawking visited the island as part of a science conference where he allegedly participated in an underage orgy. The documents do not prove guilt, but they document allegations that were serious enough to end a royal career. On February 1, 2026, British Prime Minister Keir Starmer suggested that Mountbatten Windsor should tell American investigators what he knows about Epstein's activities. Mountbatten Windsor had not responded to a request from members of the U.S. House Oversight Committee for a transcribed interview about his long-standing friendship with Epstein. Bill Clinton. Epstein's deposition from September 2016 is notable for what it does not contain. Lawyers asked Epstein to describe all dinners he ever had with Bill Clinton. Epstein invoked the Fifth Amendment. They asked him to list every place he and Bill Clinton had been together. Fifth Amendment. They asked whether Clinton visited his private island. Fifth Amendment. They asked whether Clinton flew on his private plane. Fifth Amendment. They asked about his interactions with the Clinton Foundation. Fifth Amendment. In her 2016 deposition, Johanna Schoberg recalled that Epstein told her Clinton likes them young, referring to girls. Flight logs released in the Maxwell case show Clinton's name appeared multiple times. Clinton has stated through his spokesperson that he took a total of 4 trips on Epstein's aircraft in 2002 and 2003. He has denied visiting Epstein's island. He has denied knowledge of Epstein's crimes. Maxwell's team claims that former FBI Director Louis Freeh submitted a report wherein he concluded that President Clinton did not, in fact, travel to, nor was he present on, Little St. James Island between January 1st, 2001 and January 1st, 2003. The report notes that Secret Service, assigned to the former president, would have been required to file travel logs. According to Epstein's flight logs, Clinton never flew on one of Epstein's planes near the U.S. Virgin Islands. In July 2019, a Clinton spokesperson issued a statement saying Clinton never visited the island. The documents do not accuse Clinton of criminal conduct, but they document a relationship that Epstein himself refused to discuss under oath. Donald Trump. Trump's name appears in the files as well. In December 2016, Vanity Fair published interviews with White House Chief of Staff Susie Wiles, in which she stated that Trump is named in the Epstein Files, but is not in the file doing anything awful. Depositions described Trump attending social events where Epstein was present in the 1990s and early 2000s. Trump has acknowledged knowing Epstein socially during that period. In 2002, Trump told New York Magazine that Epstein was a terrific guy and that he had known him for 15 years. Trump noted that Epstein likes beautiful women as much as I do, and many of them are on the younger side. Trump later distanced himself from Epstein. In 2019, Trump told reporters he was not a fan of Jeffrey Epstein and that he had a falling out with him many years ago. The documents do not accuse Trump of participating in Epstein's crimes. They document a social connection that Trump himself described publicly before Epstein's arrest. Alan Dershowitz. The documents contain specific allegations against Harvard Law professor Alan Dershowitz. An unnamed woman, identified as Jane Doe No. 3, alleged that Epstein required her to have sexual relations with Dershowitz on multiple occasions when she was a minor. Epstein's housekeeper, Juan Alessi, testified that Dershowitz would often visit Epstein's Florida mansion to get massages. Alessi testified that he drove Dershowitz to Epstein's house. Another household employee, Alfredo Rodriguez, stated that Dershowitz would be present at Epstein's residence without his family and in the presence of girls. Dershowitz has vehemently denied these allegations. In a Fox News interview following the January 2024 unsealing, he stated that Jane Doe No. 3 misidentified him and that he never met her. Dershowitz has filed defamation lawsuits against his accusers. He has demanded investigations into what he claims are false allegations. Dershowitz was also part of Epstein's legal team that negotiated the 2008 non-prosecution agreement. The documents do not resolve this dispute. They document allegations that remain contested. Steve Bannon. One of the FBI memos released in January 2026 describes an interview conducted in June 2020. A witness told the FBI about former Trump advisor Steve Bannon's relationship with Jeffrey Epstein. The witness was hesitant to discuss the matter in detail because Bannon was friends with powerful people. The identity of the witness is redacted. Nearly all of the 4-page document is redacted. Bannon has never been accused by law enforcement of any Epstein-related wrongdoing. But the memo exists, and its existence raises questions about what the unredacted portions contain. Other notable names. The files reference many other individuals with varying degrees of connection to Epstein. Sergey Brin and his then fiancée, Anne Washitsky, visited the island in 2007. On December 2012, Howard Lutnick, his wife and their children visited Epstein's island where they had lunch with Epstein. Reid Hoffman visited the island in November 2014, according to Epstein's scheduling records. Former Israeli Prime Minister Ehud Barak visited the island multiple times from 2014 to 2015. Victoria's Secret models were among the guests a former Epstein employee saw there. Billionaire Les Wessner visited the island at least once. On February 2, 2026, Joanna Rubinstein resigned from her position as the chair of Sweden for UNHCR, a national partner of the United Nations High Commissioner for Refugees. Epstein Files revealed that Rubinstein had visited Epstein's private island in 2012. a visit she later confirmed, while stating she was unaware of the full extent of his crimes at the time. An independent Wired investigation analyzed location data from a controversial broker showing nearly 200 mobile devices that recorded visits to Little St. James between 2016 and July 6, 2019. The pattern of immunity. Beyond the famous names, the files reveal something more troubling. The 2008 non-prosecution agreement that U.S. Attorney Alexander Acosta approved included language immunizing any potential co-conspirators. This language was unprecedented. It protected not only Epstein, but unnamed individuals who allegedly participated in his crimes. The agreement states, upon the execution of this agreement, the United States, in consultation with Epstein, shall grant immunity from federal prosecution to Epstein and to four named co-conspirators and any unnamed potential co-conspirators. The four named co-conspirators were Sarah Kellen, Adriana Ross, Leslie Groff, and Nadia Marcinkova. Sarah Kellen has been accused by one adult victim of knowingly scheduling her flights and appointments with Epstein and Maxwell. Kellen's spokesperson stated in a 2020 statement that Kellen scheduled those appointments at the direction of Epstein and Maxwell, and was herself sexually and psychologically abused by Epstein for years. The statement noted Kellen deeply regrets that she had any part in it. A criminal investigative file from the Epstein case includes a chart with 6 women believed to be either points of contact for victims or recruiters for new victims. 5 of the 6 women have their photographs blacked out in the released documents. Only Ghislaine Maxwell appears unobscured. The description states she recruited multiple girls and may have been physically involved in some of the abuse. Maxwell was ultimately charged in 2020 and sentenced to 20 years in prison in 2022. Other 5 women have never been publicly identified. They have never been charged. A draft indictment from the 2000s describes 3 individuals employed by Epstein who facilitated his crimes. Their names are redacted. They were never charged. The pattern is clear. Epstein did not operate alone. Documents identify co-conspirators. But those co-conspirators received immunity or were never pursued. Why presence matters. Mentioned in documents does not mean guilty, but silence after decades raises questions. When powerful individuals appear in testimony, in flight logs, in contact books, in emails spanning 20 years, their response matters. Some have spoken publicly. Some have filed lawsuits. Some have issued denials. Others have remained silent. The files do not provide a verdict. They provide evidence that demands explanation. And in too many cases, no explanation has been offered. End of Act 2. Act 3. The system that protected him. Run time, 18 to 20 minutes. The 2008 non-prosecution agreement. In May 2007, Assistant U.S. Attorney Marie Villafaux, plus or minus, submitted a draft 60-count indictment against Jeffrey Epstein to her supervisors. The indictment outlined charges including conspiracy, sex trafficking of children, and traveling with intent to engage in illicit sexual conduct. A lengthy 82-page memorandum accompanied the draft. It summarized the evidence assembled in support of the charges. It addressed legal issues related to the proposed charges. The Palm Beach Police Department had identified more than 30 alleged underage victims between the ages of 14 and 23 who went to Epstein's house for massage services. Federal investigators ultimately identified more than 30 alleged underage victims and prepared a 53-page indictment of Epstein that could have sent him to prison for decades if convicted. The memorandum described various degrees of sexual contact between Epstein and the girls. It stated that victims were typically paid $200 for visits and were encouraged to find other girls to bring with them, also for pay. The investigation found that Epstein's assistant or girlfriend sometimes joined in the sexual activity. Villafaux plus or minus, planned to file the charges on May 15th. The FBI was planning to arrest Epstein shortly thereafter in the U.S. Virgin Islands. where Epstein was acting as a judge at a local beauty pageant. That indictment was never filed. Instead, on September 24, 2007, Epstein signed a non-prosecution agreement. The agreement was finalized one day before the prosecutor was prepared to indict him. The agreement was approved by then U.S. Attorney Alexander Acosta. The negotiations. Villafaux plus or minus A's disputes with her supervisors came to a head in July 2007 when she learned the office had proposed to Epstein's lawyers that the federal investigation be resolved through a plea deal between Epstein and state prosecutors. Villafaux plus or minus A believed this didn't make any sense and did not correspond to Justice Department policy. In an email to her supervisor, Matthew Menschel, that is included in the DOJ Office of Professional Responsibility report, she wrote, "It is inappropriate for you to enter into plea negotiations without consulting with me or the investigative agencies. And it is more inappropriate to make a plea offer that you know is completely unacceptable to the FBI, ICE, the victims, and me." Villafaux plus or minus A also requested that all subsequent communications from the defense be directed to her and that she be afforded an opportunity to present a revised indictment to Acosta and other senior prosecutors to counter the defense arguments. The chief of the DOJ's Child Exploitation and Obscenity section in Washington, D.C., reviewed Villafaux plus or minus A's work and reported back that while more research was needed, Villafaux plus or minus A's work was exhaustive, well done, and correctly focused on the issues as we see them. But Acosta and his supervisors overruled Villafaux plus or minus A. The terms of the agreement. Under the terms of the non-prosecution agreement, Epstein would plead guilty to 2 state prostitution-related charges in Palm Beach County Court. He would serve a minimum of 18 months incarceration. He would register as a sexual offender. In exchange, the federal government agreed to end its investigation. The agreement granted immunity from all federal criminal charges to Epstein and to 4 named co-conspirators and any unnamed potential co-conspirators. Epstein served 13 months in county jail. He received gain time, that is, time off for good behavior. He was granted work release privileges that allowed him to spend up to 16 hours a day, 7 days a week, at a West Palm Beach office building and his home on Palm Beach Island. He was released in July 2009. This was the only non-prosecution agreement Acosta implemented during his tenure as U.S. Attorney. The defense team. Epstein's defense team included some of the most prominent attorneys in the country: Jay Lefkowitz, Alan Dershowitz, Kenneth Starr, the former independent counsel who investigated President Clinton. His legal strategy involved direct communication with prosecutors at the highest levels. Meetings were held off-site. Commitments were made privately. The Miami Herald investigation described this as an unusual level of coordination between federal prosecutors and Epstein's defense team. Former officials called it unorthodox. An email from Epstein's attorney Jay Lefkowitz after a meeting with Acosta stated, "Thank you for the commitment you made to me during our October 12th meeting." He added that he was hopeful that Acosta would abide by a promise to keep the deal confidential. Lefkowitz continued, "You assured me that your office would not contact any of the identified individuals, potential witnesses, or potential civil claimants and their respective counsel in this matter. It raises the question, would an indigent defendant with a public defender have received the same consideration? The answer is obvious. Wealth does not guarantee guilt, but it shapes the contours of accountability in ways that are difficult to ignore. The violation of victims' rights. The agreement was reached in secret. In 2008, representatives for 2 of Epstein's victims filed a lawsuit in federal court. The lawsuit alleged that the non-prosecution agreement violated the Crime Victims' Rights Act. The Crime Victims' Rights Act requires that victims be notified of the progress of federal criminal cases. It requires that prosecutors confer with victims before entering plea agreements. The victims in the Epstein case were not notified. They were not consulted. They learned about the agreement only after it was finalized. 1 week after Epstein entered his guilty pleas in state court in June 2008, 2 alleged victims filed the lawsuit against the federal government. On February 21, 2019, a federal judge in West Palm Beach ruled in favor of the victims. Judge Kenneth Mara determined that federal prosecutors under the leadership of Acosta violated the Crime Victims' Rights Act by not conferring with the alleged victims prior to entering the deal. The ruling was issued more than 10 years after the agreement was signed. By that time, Epstein had been living freely. He had traveled internationally. He had continued his social and business activities. And according to later allegations and investigations, he had continued to abuse victims. The court was in the process of determining if Epstein's deal should be rescinded. But then Epstein died by suicide in custody in August 2019. The case was then dismissed. But one of the alleged victims, Courtney Wild, has appealed that ruling to the 11th Circuit Court of Appeals. Courtney Wild has alleged that she was recruited as a 14-year-old by a peer to Epstein's Palm Beach home, under the expectation that she would be giving an older man a massage. She alleges that Epstein sexually abused her multiple times over the next 2 years. The decision-makers. Alexander Acosta served as U.S. Attorney for the Southern District of Florida from 2005 to 2009. In 2017, President Donald Trump nominated Acosta to serve as Secretary of Labor. Acosta's handling of the Epstein case was discussed during his confirmation hearing. He was confirmed. In November 2018, the Miami Herald published an investigation detailing Acosta's role in the Epstein case. The investigation revealed the extent of collaboration between federal prosecutors and Epstein's attorneys in their efforts to keep victims from learning of the agreement. The investigation showed in detail how Epstein coerced young girls into engaging in sexual activity and continued to do so even after the deal with prosecutors. After Epstein was arrested on new charges in July 2019, Acosta faced renewed criticism. He held a televised press conference on July 10, 2019, defending his decision. Acosta stated, "The goal here was straightforward. Put Epstein behind bars, ensure he registered as a sexual offender, provide victims with a means to seek restitution, and protect the public by putting them on notice that a sexual predator was within their midst." He also claimed the Palm Beach State Attorney's Office was ready to allow Epstein to walk free with no jail time, nothing. Critics noted that Epstein served only 13 months, that he was allowed extensive work release, that victims were never notified, that co-conspirators received immunity. Acosta resigned as Secretary of Labor on July 19, 2019, after the backlash became a distraction for the Trump administration. The Justice Department review. In November 2020, the Department of Justice Office of Professional Responsibility released a report on the Epstein non-prosecution agreement. The report concluded that Acosta's decision to decline to initiate a federal prosecution of Epstein was within the scope of his authority. The report found no evidence that his decision was based on corruption or other impermissible considerations, such as Epstein's wealth, status, or associations. Nevertheless, the report concluded that Acosta's decision to resolve the federal investigation through the non-prosecution agreement constitutes poor judgment. The report found that Acosta failed to ensure that victims were made aware of court proceedings related to their own cases. It found that he failed to ensure that victims were treated with forthrightness and dignity. The report concluded that the decision to postpone notifying victims about the terms of the agreement after it was signed did not constitute professional misconduct. It found that these actions were based on strategic concerns about creating impeachment evidence that Epstein's victims had financial motives. But the report also found that Acosta should have ensured more effective coordination and communication during the negotiations and before approving the final non-prosecution agreement. It found that the NPA was a unique resolution, and one that required greater oversight and supervision than Acosta provided. Victims weren't informed of, or consulted about, the deal before its signing. They were left, the report said, feeling confused and ill-treated by the government. Brad Edwards, who now represents more than 50 alleged victims of Epstein, derided the report for backing into the conclusions they wanted. They decided before it started, how are we going to reach the conclusion that there was no wrongdoing or that the victims' rights weren't violated? And let's figure out a way to maneuver around the actual facts and reach those conclusions. The report left victims feeling vindicated in their criticism, but frustrated by the lack of accountability. Acosta was not charged with misconduct. He was not disciplined. He was found to have used poor judgment. That finding changed nothing. Why the system failed. The Epstein case reveals multiple points of institutional failure. First, the investigation was halted before it was complete. The Office of Professional Responsibility report noted that the FBI continued to locate additional victims even after the agreement was signed. Many had not been interviewed. Second, no effort was made to gain the cooperation of alleged co-conspirators before granting them immunity. The immunity language was unprecedented and unusually broad. Third, the decision to keep the agreement secret from victims violated federal law. This was not a matter of judgment. It was a violation of the Crime Victims' Rights Act. Fourth, state authorities allowed Epstein work release privileges that effectively turned a jail sentence into a minor inconvenience. Fifth, the federal government did not pursue new charges until more than a decade later, and only after investigative journalism forced the case back into public attention. These are not isolated failures. They are systemic failures that compounded over time. End of Act 3. Act 4. Death, Maxwell, and fragmentation. Runtime, 18 to 20 minutes. August 10th, 2019. On August 10th, 2019, at approximately 6:30 in the morning, corrections officers at the Metropolitan Correctional Center in New York discovered Jeffrey Epstein unresponsive in his jail cell. He was hanging from the side of his bed. An orange noose fashioned from a sheet was around his neck. Officers performed CPR. Epstein was transported in cardiac arrest to New York Downtown Hospital. He was pronounced dead at 6:39 a.m. Epstein had been arrested on July 6, 2019, on charges of sex trafficking and conspiracy. Prosecutors asserted that agents searching Epstein's Manhattan residence found thousands of photos of nude and half-nude females, including at least one believed to be a minor. Beginning in at least 2002 and continuing until 2005, Epstein is alleged to have abused dozens of victims by causing them to engage in sex acts with him at his mansion in New York and at his estate in Palm Beach, Florida. He pleaded not guilty. He was denied bail after offering $600,000 to be able to wear an ankle tracker at his New York City townhouse. He was viewed as a potential flight risk because of the 20 international flights he had taken in the previous 18 months. He was awaiting trial. That trial would have brought extensive evidence into public view. Victims would have testified. Documents would have been entered into the record. That trial never happened. The official conclusion. The New York City medical examiner ruled Epstein's death a suicide by hanging. An autopsy was conducted on August 11th. The medical examiner's office reported that Epstein had hanged himself with a sheet from his bed. The Department of Justice Inspector General launched an investigation. In June 2023, Inspector General Michael Horowitz released a report. The report found no evidence to suggest anything other than suicide. It found no evidence of foul play. No physical evidence supported conspiracy theories. Video footage showed no indication of anyone else in the cell. Investigators probed for possible money changing hands involving guards, but found no evidence of that either. The FBI concurrently investigated whether Epstein's death was the result of criminal conduct by any non-DOP actors. Among other things, The FBI investigated the cause of Epstein's death and determined it was not the result of a criminal act. All MCC New York staff members who were interviewed by the OIG said they did not know of any information suggesting that Epstein's cause of death was something other than suicide. Additionally, none of the 15 inmates who agreed to be interviewed in connection with this investigation, 10 of whom were housed in the SHU on August 9th and 10th, had any credible information. The report concluded that Epstein died by suicide. But the report also documented extensive failures that made that suicide possible. The failures. The Inspector General's report identified numerous and serious failures by Metropolitan Correctional Center staff. First, Epstein was supposed to have a cellmate. Following an incident on July 23rd in which Epstein was found with marks on his neck, the psychology department determined he needed to be housed with an appropriate cellmate. Epstein was placed on suicide watch for 31 hours after what jail officials said was a suicide attempt that left his neck bruised and scraped. On August 9th, Epstein's cellmate was transferred out. Staff knew Epstein did not have a cellmate, but did not take steps to ensure he was assigned a new one. As a result of the failure to assign him a new cellmate, Epstein was housed alone in his cell from the night of August 9th. Second, staff failed to conduct required 30-minute rounds. The report found that no rounds were conducted after approximately 10:40 p.m. on August 9th. Third, staff falsified count slips and round sheets to show that counts and rounds had been performed when they were not. 2 staff members assigned to Epstein's unit, Tova Noel and Michael Thomas, repeatedly failed to complete the required prisoner's check during their watch. Fourth, Epstein's cell was not searched as required. Had it been searched, staff would have discovered that Epstein had excess prison blankets, linens, and clothing. Fifth, the security camera system was not fully functional. Nearly all cameras in and around the special housing unit where Epstein was housed did not record video starting in late July 2019. Although video cameras in the SHU provided live video feeds to monitoring stations, system deficiencies resulted in nearly all of the cameras in and around the SHU where Epstein was being housed to not record video starting in late July 2019 and continuing through the date of Epstein's death. The combination of these and other failures led to Epstein being unmonitored and locked alone in his cell, which the OIG found contained an excessive amount of bed linens, from approximately 10:40 p.m. on August 9th until he was discovered hanged in his cell. 2 corrections officers, Tova Noel and Michael Thomas, were charged with falsifying records. The charges were later dismissed under deferred prosecution agreements. According to the initial indictment, both individuals agreed to complete 100 hours of community service and cooperate with the DOJ's Inspector General review. The U.S. Attorney's Office for the Southern District of New York declined to prosecute other MCC employees who the OIG found certified or submitted false documentation regarding the inmate counts on the days surrounding Epstein's death. No supervisors were punished. No Bureau of Prisons officials were disciplined. The failures were extensive, but they were characterized as negligence, not conspiracy. The questions that remain. In September 2025, CBS News conducted an analysis of surveillance video from the jail. Video released by the Justice Department and FBI shows a view of the Special Housing Unit on August 9th, 2019. The video begins at 7:40 p.m., 9 minutes later. According to the report of the Justice Department Inspector General, Epstein appears for the first and last time on camera. He emerges from the left side of the screen and walks down a stairwell, accompanied by a corrections officer. At 6:30 a.m., corrections officers can be seen rushing across the frame. That's when Epstein's body was discovered. The Inspector General's report says only 2 staff members entered the unit after midnight. One is a corrections officer, identified only as CO3, and the other is described as the Morning Watch Operations Lieutenant. The analysis identified an orange-colored shape moving up a staircase toward Epstein's cell tier at approximately 10:39 p.m. on August 9th. An FBI observation log described the image as a flash of orange that could possibly be an inmate escorted up to that tier. Independent video analysts consulted by CBS News stated that the movement was more consistent with an inmate or someone wearing an orange prison uniform than a corrections officer. The presence of a third unidentified individual seen on the video is not addressed by the Inspector General's report. Official reviews of Epstein's death made no mention of this figure. Attorney General William Barr stated publicly that his personal review of surveillance footage clearly showed that no one entered the area where Epstein was housed. The discrepancy has not been explained. Additionally, documents show that the recorded number of inmates in the special housing unit appeared to drop from 73 to 72 sometime between 10 p.m. and midnight on August 9th. Corrections officers were not specifically asked about the orange-colored figure. One officer stated he had no recollection of the period between 10 p.m. and midnight. These details do not prove foul play, but they illustrate gaps in the official account. Why documentation becomes a threat. Epstein's death ended the criminal case against him. The trial that would have exposed the full scope of his operation never occurred. Witnesses who prepared to testify were never called. Evidence that would have been entered into the public record remained sealed. His death also triggered legal arguments about the status of the investigation. Defense attorneys for Ghislaine Maxwell cited the non-prosecution agreement in their appeals. They argued that the immunity granted to co-conspirators should apply to Maxwell. Epstein's death fragmented accountability. It shifted the focus from his crimes to the circumstances of his death. It allowed conspiracy theories to flourish. It left victims without the closure that a trial might have provided. And it ensured that millions of documents would be released incrementally over years through multiple legal processes, making comprehensive understanding nearly impossible. When accountability disappears, documentation becomes a threat. Not a threat to the guilty, a threat to the possibility of ever knowing the full truth. The Maxwell Trial. Ghislaine Maxwell, a British socialite and longtime friend of Epstein's, was arrested in July 2020 and charged with 6 federal crimes, including enticement of minors, sex trafficking of children, and perjury. The indictment charged that between 1994 and 1997, she assisted, facilitated, and contributed to the abuse of minor girls, despite knowing that one of 3 unnamed victims was 14 years old. Maxwell's jury trial commenced on November 29, 2021. It entailed testimony from 4 women who described the sexual abuse they had suffered as girls at the hands of Epstein and Maxwell. Testimony of individuals who had worked for Epstein and Maxwell. Testimony of law enforcement officials. Corroborating physical and documentary evidence, including Epstein and Maxwell's black address book, flight logs of Epstein's private planes, and FedEx records. The 4 accusers. The first accuser to testify did so under the pseudonym Jane Doe. Jane went over the timeline of alleged sexual abuse beginning in 1994, when she was 14, until 1999. Jane testified that Maxwell and Epstein had preyed upon her as she attended summer arts camp in 1994. The 2 predators set up a pyramid scheme in which they would reward with additional money vulnerable girls who brought to them another vulnerable girl. Jane testified that the first time Epstein made sexual contact with her was at the pool house of his Palm Beach home. He sat on a couch or futon, pulled Jane down on him, and proceeded to masturbate. He then walked off to the bathroom, while she said she was frozen in fear. She recalled a different occasion where she said Maxwell and Epstein removed their clothing and got into bed together while she stood there. She said they began fondling each other and giggling. Jane said she was asked to take her top off and remembered there were hands everywhere, and Epstein masturbated while Maxwell kissed him. The second accuser testified under the pseudonym Kate. This time, Epstein was standing naked when Maxwell brought Kate to the same room and closed the door behind her. "Have a good time," Maxwell said as she left the room, according to the testimony. In her testimony, Kate testified she traveled at Epstein's expense several times to New York, Palm Beach, Florida, and Little St. James in the U.S. Virgin Islands. Maxwell invited her to Epstein's private island to give him massages and would inform Kate of the travel arrangements. Kate testified that in conversation, Maxwell would tell Kate that Epstein needed to have sex 3 times a day. When asked about Maxwell's demeanor during these talks, Kate said she often sounded like a schoolgirl and talked as if she were younger than teenage Kate, which she found odd. The third accuser testified under the pseudonym Carolyn. Carolyn said she was sexually abused for years by Jeffrey Epstein, starting when she was 14 years old. Carolyn went back to Epstein's hundreds of times over the next several years. She said, and there was a sexual encounter each time. In the beginning, Carolyn said, Maxwell would call her to arrange the appointments. "I was young," she said, "and $300 was a lot of money to me." On one occasion, Carolyn testified, Maxwell entered the massage room while Carolyn was fully nude. Maxwell touched her breasts, she said, and told her that she had a great body for Mr. Epstein and his friends. Carolyn also said Maxwell allegedly groped her once while she was setting up the massage table in Epstein's bathroom. The fourth and final accuser, Annie Farmer, testified under her full name. Annie Farmer, who has spoken out publicly about Epstein and Maxwell for years, spoke in open court during both Epstein's 2019 bail hearing and Maxwell's bail hearing a year later. She testified for 3 hours. Her older sister worked for Epstein, and Farmer met him during the 1995 holiday season. Epstein paid for her commercial flight to New York, and at a movie held hands with her and caressed her foot. She described going to the billionaire's ranch in New Mexico in 1996 at age 16, where she thought she would be joining other peers, but she was the only teen there. Trial ended on December 29, 2021 with Maxwell's conviction on 5 felony counts: conspiracy to entice minors to travel to engage in illegal sex acts, conspiracy to transport minors with intent to engage in criminal sexual activity, transporting a minor with the intent to engage in criminal sexual activity, conspiracy to commit sex trafficking of minors, and sex trafficking of minors. She was acquitted on the substantive enticement count. On June 28, 2022, Maxwell was sentenced to 20 years in prison. Prosecutors were seeking a sentence of at least 30 years. In her concluding verdict, the judge said, "The evidence at trial established that Ms. Maxwell directly and repeatedly, and over the course of many years, participated in a horrific scheme to entice, recruit, and traffic underage girls for sexual abuse." Maxwell sought a retrial on the grounds that a juror did not disclose during jury selection that he had been sexually abused as a child. On April 1, 2022, the judge found that the juror's failure to disclose his abuse as a child did not warrant a new trial and dismissed Maxwell's request to set aside the verdict. According to prosecutors, the testimony elicited at Maxwell's trial demonstrated she was a vital participant in Epstein's crimes, offering a veneer of respectability and trust before the convicted sex offender abused dozens of teenage girls. She identified and preyed on vulnerable young women, groomed them to normalize their abuse, and participated in the abuse, directly enabling one of the most significant sex trafficking operations in U.S. history. Maxwell befriended her victims, won their trust, slowly broke down their boundaries, and normalized sexual abuse. Maxwell's victims trusted her. She was a seemingly respectable woman who showed interest in them and promised to help them. She was key to the entire operation of the scheme, and Epstein could not have committed these crimes without her. Maxwell's current status. Maxwell is appealing her conviction on sex trafficking and other charges. She has asked the Supreme Court to take up her case, and any potential reversal could result in a new trial. In December 2025, representing herself, Maxwell filed a habeas petition, asking a federal judge to free her on grounds that substantial new evidence has emerged, proving that constitutional violations spoiled her trial. Maxwell claimed exonerating information was withheld and that witnesses lied in their testimony. Todd Blanche, Trump's former personal lawyer and current Deputy Attorney General, interviewed Maxwell in closed-door meetings in July 2025 for more than 9 hours over 2 days. Following the interview, Maxwell was moved from a low-security prison in Florida to a low-security prison camp in Texas, in violation of Bureau of Prisons rules on housing sex traffickers. The Trump administration is debating releasing transcripts of Blanche's interview with Maxwell. Lawyers Brad Edwards and Paul Kessel, who represent numerous victims, including a woman who testified at Maxwell's criminal trial, questioned the motives of the Justice Department as the Trump administration tries to tamp down criticism. For survivors who bravely testified, the perception that Ms. Maxwell is being legitimized in public discourse has already resulted in re-traumatization. Another law firm representing Annie Farmer noted her concern that Maxwell will benefit from the recent confluence of events. Epstein escaped justice through his apparent suicide, and Maxwell is now, to the victim's horror, herself attempting to escape justice by negotiating for herself a potential pardon or commutation of her sentence. The victims of her crimes unequivocally object to any potential leniency that the government may be considering offering Maxwell, a convicted sex trafficker. The dispersion of attention. Since Epstein's death, the story has been told in fragments. Court unsealing. Congressional hearings. Investigative journalism. Document dumps. Redactions. Appeals. Inspector General reports. Each fragment captures attention briefly. Each generates headlines. Each produces reactions on social media. But fragments do not coalesce into understanding. The public has been given millions of pages of documents, but those documents are scattered across jurisdictions, released in waves, heavily redacted, and embedded in legal proceedings that most people cannot follow. Attention is finite. The news cycle is relentless. Complexity exhausts interest. 3 million pages sounds overwhelming. It is designed to be. Not through malice. Through the ordinary functioning of a bureaucratic system that prioritizes procedure over clarity, legal compliance over public understanding, institutional protection over accountability. The Epstein Files will never be complete. Grand jury materials remain sealed. Some will be released. Others will remain protected by laws designed to safeguard the integrity of investigations. Attorney-client privilege claims will be litigated. Some will be upheld. Others will be challenged. Victims will continue to pursue civil litigation. New documents will emerge. Old documents will be re-examined. But there will never be a final report. There will never be a definitive account. There will never be a moment when all questions are answered. The story of the Epstein Files is a story of permanent incompletion. It is a story of power, not because powerful people conspired to hide evidence, but because power itself creates systems that make accountability difficult, fragmented, and easily deferred. This has been an investigation into what the Epstein Files actually contain. Not rumors, not speculation, not conspiracy theories, documents, testimony, official reports. We have examined what exists and what it reveals. We have examined how the system responded and how it failed. We have examined why millions of pages of documents have not produced the accountability that victims deserve. The files are not a secret. They are public. You can read them yourself. But reading them requires time, expertise, and a willingness to sit with uncomfortable truths about how parades, how institutions fail, and how complexity itself can be a form of protection. The question is not whether the files exist. The question is what we do with them. Final title card. This is only part 1. If you want part 2, focusing entirely on specific documents and testimonies, leave a comment and say part 2.